Hi everyone, welcome back to the channel. On today's story, a woman disappears 3 weeks after filing for divorce. Her car turns up abandoned less than a mile from her house. One tire shredded, her purse gone, her Halloween costume still folded on the seat. Her phones are found smashed nearby. 6 weeks later, her body is found under a tangle of kudzu vines near a cemetery. And then nothing happens. No arrest, no charges. For 11 years. Today we're diving into the death of Karen Swift, a Tennessee case that finally went to trial in 2024, more than 12 years after she vanished. And still, as of this year, has not produced a single conviction. This is a story about a marriage that was ending, a case that almost didn't survive the calendar, and a legal system that, in the end, answered fewer questions than it raised. Let's start at the beginning. Karen Johnson Swift was 44 years old, a mother of 4, living in Dyersburg, Tennessee, a small city in the northwest corner of the state. According to one biographical account, Karen and David had married back in September of 1989, and according to a single source, had even divorced and remarried each other once before, in the year 2000. Neither detail is confirmed by more than one account, so let's treat it as a background color more than settled fact. What is well documented is where things stood by at the fall of 2011. The marriage was coming apart. On October 10th, 2011, Karen filed for divorce. Court records show exactly what she was asking for. Custody of the couple's minor children, roughly $1,400 a month in child support, permanent alimony, a share of David's bonuses, reported at this time about around $25,000, and a division of the property the two of them held together. This wasn't a quiet separation. This was a formal, detailed filing, the kind that spells out on paper exactly what a marriage is worth and exactly what each side believes they're owed. 3 weeks later, however, Karen was gone. On the night of October 29th, 2011, Karen went to a Halloween party at a local country club. According to David's own account to investigators, she left sometime after midnight to pick up one of their daughters from a sleepover. Separately, cell phone records introduced at trial years later established a timeline of their own. Karen's phone stayed at the house between roughly 2:08 and 4:38 in the morning. Then, at 5:04 a.m., the same phone left the house. 5 minutes later, at 5:09 a.m., it went silent. It never came back on. David told investigators he woke up around 10 o'clock that morning and couldn't find her. Accounts differ on exactly when the alarm was formally raised. Most reporting places the missing persons report on October 30th, the same morning David says he woke to an empty house. One contemporaneous news account from that period puts it a day later, on the 31st. What isn't in dispute is how quickly the physical evidence turned up and how disturbing it was. Karen's SUV, a 2004 Nissan Murano, was found abandoned near her home, somewhere between a quarter mile and roughly a mile away, depending on which account you read. One of its tires was shredded. Her purse was missing. Her Halloween costume from the night before was still inside the vehicle. And not far from the house, in the direction of a neighboring property, Karen's 2 cell phones turned up smashed. Think about what that combination tells you, and what it doesn't. A car abandoned nearby, not fled in. A purse gone, but a costume left behind. 2 phones destroyed, not just dropped or lost. The scene left investigators with questions that would remain central to the case for years. deputies searched the Swift home and impounded the vehicle that same weekend. Sheriff Jeff Boggs' office brought in canine units to search the surrounding area. And in the earliest news coverage, in the first days of November 2011, the people who knew Karen best said the same thing, over and over. She would never have left her children voluntarily. There's also a quieter detail worth sitting with. Karen's divorce case didn't stop just because she disappeared. In the middle of November 2011, while investigators were still searching for her, attorneys on both sides of that divorce filed contested motion in the case that was still technically open. Karen's attorney moved to depose David. David's attorney moved to quash that request, citing her disappearance, and separately moved to have opposing counsel removed over an alleged conflict of interest. The paperwork of a marriage ending kept grinding forward on its own legal timeline, even after the woman at the center of it had vanished. One detail from the vehicle itself would resurface at trial more than a decade later. A responding officer, a man 6'2", testified that he was able to get into the driver's seat of Karen's SUV without adjusting it further back. Prosecutors would later use that testimony to suggest that whoever had last driven the vehicle might have been smaller in stature than David Swift. It's worth being precise about what that testimony actually establishes. A seat position and an officer's observation about it. It doesn't by itself identify a driver. There was also the tire. A tire technology expert testified years later that a screw found in it appeared to have been manually inserted, and the damage was consistent with the vehicle being driven on a fully collapsed tire. That's the expert's interpretation of physical evidence, not an eyewitness account, and the defense contested it at trial. In the first days after Karen disappeared, investigators had at least one other person of interest close to home. On November 5, 2011, a neighbor named John Hogshuter was arrested for aggravated animal cruelty, accused of poisoning 2 dogs, including one belonging to the Swift family, just days before Karen vanished. Police searched his home and vehicle, and then according to reporting from that period, they found nothing tying him directly to Karen's disappearance, so he was eventually cleared as a suspect in her case. But eventually cleared rests on second-hand characterization rather than a released clearance document, and it clearly wasn't the end of the story for the defense. When David Swift went to trial in 2024, his lawyers brought Hogshuter back into the narrative, pointing to his access to construction tools as a contractor and arguing he remained a plausible alternative explanation the state had never fully closed the door on. On November 10, 2011, Tennessee's Bureau of Investigation sent its Violent Crimes Response Team to process the Swift residence for trace evidence. And then for 6 weeks, Karen Swift's family waited without an answer. On December 10th, 2011, that waiting ended. Karen's body was found under kudzu vines near Bledsoe Cemetery, roughly 3 miles from where her SUV had been abandoned, about 100 yards from a large roadside cross visible from the highway, and according to figures cited at trial years later, only about 20 feet from the road itself. The next day, dental records confirmed her identity, and the case was formally reclassified as a homicide. The autopsy findings recorded that December were stark. The cause of death was blunt force trauma to the head, an 8x4 centimeter fracture to the right side of her skull, comminuted and depressed, with bone fragments driven into the brain. There was a fractured rib. A second hairline fracture on the left side of the skull was described in the report as consistent with a collapse. Karen's body was found nude except for her underwear, which had been pulled down to her thighs. But the state of decomposition after 6 weeks outdoors made it impossible for the medical examiner to determine whether a sexual assault had occurred. No alcohol or drugs were found in her system. In March of the following year, the county medical examiner's office filed a follow-up investigative report confirming the homicide classification and noting that Karen's body had been deliberately concealed beneath the kudzu. A homicide. Her body had been concealed beneath the kudzu, and still no one was charged. For the next several years, the case moved in fits and starts. In 2013, investigators searched the Swift residence again and collected additional evidence. But the district attorney at the time, Phil Bivens, said publicly in 2014 that there simply wasn't enough to charge anyone. That same year, Karen's mother, Carol Johnson, gave her first televised interview, describing the toll of not knowing. Investigators, for their part, said publicly that David was the person they most wanted to sit down and ask directly. Did you kill your wife? And it's worth being clear about what that kind of statement is. A description of where law enforcement's suspicion had not settled, not a finding of fact, and certainly not evidence in itself. By 2014, David had already a defense attorney on record, Steve Faris, representing him through what was then still officially a person of interest phase rather than a formal charge. A distinction worth holding on to, since suspicion and criminal charge are not the same thing under the law. However, the two might look the same from the outside. Years passed. In October of 2019, 8 years after Karen disappeared, the Dyer County Sheriff's Office formally closed out its own investigation and handed the entire file over to District Attorney Danny Goodman's office for review. Somewhere in that stretch of years, David Swift took an unusual step of his own. In April of 2020, he filed a defamation lawsuit against a private investigator named Heather Cohen over public statements she'd made linking him to Karen's death. The following year, he invoked Tennessee's anti-SLAPP law to try to get that suit dismissed on his own terms. The final outcome of that lawsuit isn't part of the public record reviewed for this story, but the lawsuit itself shows a man actively pushing back in court against the public suspicion that had followed him for nearly a decade. Then, in February of 2022, the TBI went back to the house one more time, executing a fresh search warrant at what had once been the Swift family home. 6 months later, on August 8, 2022, a Dyer County grand jury indicted David Swift for premeditated first-degree murder. He was arrested that same day in Alabama. He waived extradition the following day, and on August 10th, he was arraigned before Circuit Judge Mark Hayes in Tennessee, held without bond, with a public defender initially appointed to him. And by the end of the month, a judge had set bond at $200,000 with GPS monitoring, a no-contact order, and his movement restricted to Tennessee, Mississippi, and Alabama. He posted it and was released to await trial. 11 years after Karen Swift disappeared, the man investigators had suspected from the start was finally facing formal charges, though the jury that would decide his case was still nearly 2 years away. Before that trial arrived, one more complication entered the picture, this one involving David's life after Karen. He had remarried. His second wife, Kelly Essman, filed for divorce from him in June of 2022, and that divorce was finalized in March of 2023. A few months later, on July 9th, 2023, Essman alleged that David had shown up and surveilled her home overnight, part of a broader pattern she says continued after their divorce. He was arrested in Jefferson County, Alabama on first-degree stalking charge on July 21st, 2023, an arrest that also triggered the revocation of his bond in the Tennessee murder case, sending him back into custody there. That Alabama stalking charge is a separate legal matter from Karen's death. It doesn't establish anything about what happened to Karen, but it became part of the public picture surrounding David Swift as his murder trial approached, and Esmond would later speak publicly about her experience. In December of 2023, Judge Hayes granted a change of venue, moving the eventual trial out of Dyer County to a jury pool in Weakley County, and confirmed the trial date, May 28, 2024. The trial ran 9 days, from May 28th through June 6, 2024, in front of Judge Hayes, with defense attorney Daniel Taylor leading David Swift's defense and Assistant District Attorney Tim Box working alongside DA Danny Goodman for the state. Right out of the gate, the prosecution made an unusual admission. There was no DNA, no fingerprints, no ballistic evidence connecting David Swift to the killing. The state's case, prosecutors told the jury directly, would rest on circumstantial evidence, motive, opportunity, and a pattern of behavior. The defense's answer was just as direct. No forensic evidence, no proof, and they raised something else, a documented knee injury that they argued made it physically implausible for David to have carried out the crime as prosecutors described it, or to have moved and concealed Karen's body afterward. The state pushed back on that specific point with 2 witnesses of their own. A neighbor testified that David had been seen moving 65-pound hay bales without the aid of crutches. And a physical therapist offered a professional opinion that, despite the injury, David had the physical capacity to drag a 125-pound weight, roughly Karen's size, across the estimated 75-foot distance investigators believed separated the road from where her body was found. That's expert opinion testimony about physical capability in general terms. It doesn't establish that David actually did any of that on the night Karen disappeared. Only that the defense's central physical argument was directly contested at trial, witness against witness. Over the following days, 36 witnesses took the stand for the prosecution. Friends of Karen's, among them a couple named Bill and Kathy Bona, described what they called controlling and jealous behavior from David in the months before her death, along with a tense social dynamic involving the 2 families that, according to David's own statements to police, he believed involved infidelity and an attempted assault on Karen. The Bonas, testifying themselves, disputed that characterization. They confirmed that some nude hot tub gatherings had taken place, but denied any assault had ever been attempted. Several other neighbors, friends, and a co-worker described what they characterized as surveillance-like possessive behavior from David towards Karen. It's important to hold on to exactly what this testimony is. Descriptions from people who knew the couple, of a pattern they observed. The defense, for its part, argued this reflected concern rather than control, and pointed out that none of these witnesses had alleged actual violence. A tire expert then testified about that shredded tire and the screw investigators believed had manually been inserted. DNA analysts told the jury that no male DNA was found on Karen's underwear, and nothing beyond her own DNA was recovered from her fingernails. That absence matters, and it cuts in more than one direction. It doesn't establish that a sexual assault didn't happen, since decomposition had already ruled that determination out. And it doesn't on its own clear anyone of causing the blunt force injuries that killed her, since an attack like that doesn't necessarily leave DNA behind in those particular samples. The medical examiner returned to the stand to walk the jury through the autopsy findings. Blunt force trauma to the head, the same fractures documented back in 2011. During that questioning, the prosecutor raised the possibility that Karen had been strangled before she was struck, suggesting that combination might explain the pattern of the skull fracture. It's worth flagging exactly what that moment in the trial was. A theory, raised by the prosecutor during questioning, not a conclusion stated in the original autopsy report itself. No source reviewed for this story identifies any independent forensic findings. No marks consistent with strangulation, for instance, that would confirm that specific two-part theory. On June 3rd, the state rested, closing with testimony from a TBI digital forensic examiner named Joel Wade, whose findings we'll get to in a moment. The defense asked the judge to acquit David on the spot, arguing the state hadn't met its burden. The judge disagreed, ruling there was enough circumstantial evidence to let the jury decide. The next day, the defense called 6 witnesses of its own, including 2 of the Swift children, called to testify for their father. David Swift did not take the stand himself. When the defense rested, the count stood at 36 witnesses for the state against 12 for the defense. Closing arguments came on June 5th. Prosecutors told the jury David killed Karen because she wouldn't reconcile with him, because the divorce and everything it meant was becoming final and irreversible. The defense's closing came back to the same point they'd made from day one. No proof. On June 6, 2024, the jury told the judge they were deadlocked. The judge sent them back to keep deliberating. When they returned, the verdict was this: not guilty on first-degree premeditated murder, not guilty on attempted first-degree murder, not guilty on second-degree murder, not guilty on attempted second-degree murder. On the lesser charge sitting beneath all of those, voluntary manslaughter, the jury could not reach a unanimous decision at all. The judge declared a mistrial on that one count. Now, it's worth pausing here for a moment, because this is the kind of verdict that's easy to misread if you're only half paying attention. A not guilty verdict on the murder charges means the jury did not believe the state had proven those specific charges beyond a reasonable doubt. Not that the jury concluded David Swift had nothing to do with Karen's death, and not that he was cleared of everything. The mistrial on manslaughter means something different again. It means 12 jurors simply couldn't agree on that lesser charge, one way or the other. No verdict at all was reached on it. Legally, that count was still alive. And prosecutors weren't done with it. On June 20th, 2024, 2 weeks after the verdict, a new grand jury re-indicted David Swift, this time specifically on voluntary manslaughter and aggravated assault, built on the same underlying facts as the mistried count. That's when the case took its strangest turn. At what was originally scheduled as a routine bond hearing on July 2nd, 2024, David's defense instead moved to dismiss the entire re-indictment, not on the facts of what happened to Karen, but on a technical procedural ground, the statute of limitations. Here's what that means in plain terms. Tennessee law places no time limit at all on prosecuting murder, first or second degree. You can be charged with murder decades after the fact, and that's exactly what happened here. But voluntary manslaughter is a different, lesser charge, and Tennessee law does put a clock on it. The defense argued that clock had already run out. Karen died in 2011. The original indictment didn't come until 2022, 11 years later. For a first-degree murder charge, that gap doesn't matter. But manslaughter isn't murder. And the defense said prosecuting it 11 years after the fact came too late. Under the law, regardless of what the evidence showed, the judge didn't rule right away. In October 2024, an appeals court denied an earlier separate defense motion to dismiss the case, a ruling that lets keep things moving forward for the moment, though it wasn't the final word on the statute of limitations argument itself. That November, ABC's 2020 aired a documentary on the case, featuring interviews with David and Karen's daughter Ashley, who spoke on camera in defense of her father. Karen's mother, David's second wife, Kelly Essman, the lead investigator, and David himself appeared by video call from jail. A retrial date for the manslaughter charge was set for May 7th, 2025. Before that retrial could happen, prosecutors tried to strengthen their case with something new. In January of 2025, the state asked the court to admit browser history recovered from a password-protected laptop in the Swift home, a laptop investigators attributed to David. A TBI digital forensic examiner testified that between October 31st and November 10th, 2011, in the 10 days right after Karen went missing, that laptop had accessed the dating and hookup sites Match.com and Adult Friend Finder 175 times, using private browsing mode. The state's theory was straightforward. This was evidence of motive, of a marriage David wanted out of badly enough to explain what happened. What that browser history actually establishes is narrower than that. It shows activity on that specific laptop, in that specific window. It doesn't on its own establish who exactly was at that keyboard for every one of those visits, and it doesn't connect that activity to the act of killing Karen. The retrial never got the chance to weigh any of it. On March 17, 2025, Circuit Judge Mark Hayes ruled in the defense's favor on the statute of limitations argument raised back in July. He dismissed the voluntary manslaughter and aggravated assault charges entirely, not because he found David innocent, and not because he found the evidence insufficient, but because, under Tennessee law, prosecutors had simply run out of time to bring that particular charge. David Swift was ordered released from Tennessee custody, though he still faced that outstanding stalking matter in Alabama. The scheduled May retrial never happened. District Attorney Danny Goodman said publicly that he intended to appeal the dismissal because, as he put it, there was no path to refiling the charge otherwise. Whether that appeal was ever formally decided isn't something the public record confirms. At least not as of this tally. So take stock of where that leaves things. Legally, David Swift was tried by a jury for murdering his wife. He was found not guilty on every murder charge presented. The one charge left standing after that trial, manslaughter, was never resolved on its merits at all. It didn't end in acquittal, and it didn't end in conviction. It ended because the clock, under the letter of the law, had run out first. David Swift didn't stay quiet after his release. In March of 2026, he went on the offensive in a different courtroom entirely, filing a federal civil rights lawsuit against Dyer County, Sheriff Jeff Box, District Attorney Danny Goodman, and several named investigators from the sheriff's office. His claim that the people who built the case against him fabricated evidence, coerced witnesses, and withheld material that could have helped clear him, and that he was wrongfully prosecuted as a result. It's important to be precise about what that lawsuit is at this point. It's an allegation filed by David Swift that hasn't been tested or ruled on. Sheriff Box called it frivolous in response, though he noted he hadn't even been formally served with it yet. D.A. Goodman said he wasn't aware of the suit and he had no comment. Neither side of that dispute has had its claims decided. And somewhere underneath all of this legal maneuvering are the people who actually lived it. According to reporting from 2015, Karen's family relocated, moving to a town nearly an hour away from Dyersburg, citing continued harassment in the years after the investigation began. A quiet detail that says something about what it cost this family just to keep living in the place where Karen died. Karen's mother, Carol Johnson, spent more than a decade publicly pushing for answers about her daughter's death, speaking to reporters as early as 2014 and again after David's eventual arrest in 2022. One of Karen's sons, Preston, made public appeals for information back in the earliest days of the search in 2011, when his mother was still just missing, not yet confirmed dead. And more than a decade after that, one of Karen and David's daughters, Ashley, sat for a national television interview defending her father, the man a jury would go on to acquit of murdering her mother, while a lesser charge against him died on a technicality rather than a verdict. 2 of the Swift children took the stand in his defense at trial. This is a family that has now spent more than a decade split between grief for a mother and loyalty to a father. And the legal system never gave them a single final answer that might have settled which of those was the whole truth. And underneath the legal outcome, some of the most basic questions about that night were never answered at all. No weapon was ever recovered, and no source reviewed for this story identifies exactly what object caused the fracture to Karen's skull. Whether Karen was sexually assaulted couldn't be determined. The 6 weeks her body spent outdoors, exposed to the elements, took that answer away before anyone could look for it. Her purse, missing from the vehicle the day it was found, was never recovered, and nothing in the record says what became of it. And no independent account, no witnesses, no camera, nothing beyond David's own statements and the cell tower data exists for what happened inside that house between roughly 2 and 5 o'clock in the morning on October 30th, 2011. The exact window in which Karen Swift's phone was last known to be at home. So where does that leave the case of Karen Swift as it stands right now? No one has ever been convicted of killing her. A jury heard the state's best case for murder and rejected it on every count. The only charge that survived that trial collapsed, not because a jury or a judge decided David Swift was innocent of it, but because prosecutors, by Tennessee's own legal calendar, had run out of time to pursue it. The district attorney says he wants to appeal that outcome. David Swift says the entire investigation against him was built on fabricated evidence and coerced witnesses, a claim that, as of now, is untested in any courtroom. A stalking case involving his second wife sits somewhere in the Alabama court system, with its outcome unclear. And the man investigators had focused on for more than a decade is today a free man. Not exonerated, not convicted, just released with a lawsuit of his own now pending against the people who chased him for a decade. Karen Swift filed for divorce on October 10th, 2011. 3 weeks later, she was gone. More than 14 years after that, the legal system has still not told her family definitively what happened to her. Only what a jury and then a statute of limitations clock decided the state couldn't prove in time. 4 days. That's how long it had been since a Utah court dismissed a woman's protective order against her husband. When that husband vanished. 8 days after that, she called the police herself to report him missing. And months later, prosecutors would allege that the same woman who made that call had already buried him. Today, we're diving into the case of Matthew Johnson, a member of the Utah Army National Guard, and his wife, Jennifer Gledhill. A case built almost entirely on cell phone data, surveillance video, and the word of a man police had never publicly named. A case where investigators found blood in a bedroom, a gun box hidden in a child's onesie, and a storage container that surfaced on its own in a wetland after a storm. And a case where, as of the most recent reporting available, the person prosecutor says was murdered has never been found. This case involves domestic violence allegations, an alleged homicide, and the separation of young children from a parent. So viewer discretion is advised. The case is formally known as State of Utah versus Jennifer Gledhill. It was filed in Utah's 3rd District Court in Salt Lake County. It's been investigated by Cottonwood Heights Police under a case number and prosecuted by the Salt Lake County District Attorney's Office. But before there was a case number, there was just a marriage, already unraveling in the courts. Jennifer Gledhill and Matthew Johnson lived in Cottonwood Heights, a suburb tucked into the foothills southeast of Salt Lake City. Johnson, 51, served in the Utah Army National Guard. Widely reported to be affiliated with the 19th Special Forces Group, a unit affiliation corroborated by a fellow guardsman who served alongside him for 12 years. One social media post referred to Johnson as Staff Sergeant Matt Johnson, although no official military record confirming that specific rank turned up in the reporting on this case. On July 3, 2024, Jennifer Gledhill filed for divorce. 7 weeks later, on August 21st, she went further and filed for a protective order against Johnson. A judge granted it temporarily. On September 10th, a court commissioner recommended extending it another week while the evidence was being reviewed. Then, on September 16th, the order was dismissed. The commissioner found that what Gledhill had submitted, including videos she'd recorded herself, did not meet Utah's legal definition of abuse. But the ruling didn't waive the conflict away entirely. The commissioner wrote that Johnson's conduct approaches the line of placing Gledhill in reasonable fear without crossing it, and described the marriage itself as highly dysfunctional. The order, which had separately and rather unusually accidentally expired, was formally closed the same day. 4 days later, Matthew Johnson would be seen for the last time. What follows is the timeline investigators pieced together afterward, from text messages, GPS pings, and surveillance video. Some of it comes from documents. Some of it comes from one source whose name has never been made public. We'll keep track of which is which as we go along. On September 18th, according to an unsealed search warrant affidavit, Jennifer texted her father, Thomas Gledhill, "I need $13K by Friday." Nothing on the record explains why. It's the first of several threads this case never quite ties off. The next day, a second message. "Don't forget to give me your card information." Thomas sent her $1,000 through Venmo that same day, according to reporting that cited Fox 13, and separately, the man who says he was having an affair with Jennifer told police that on the same day, September 19th, she showed him a loaded handgun, a tan and green Glock 19X, and told him it belonged to her husband. Then September 20th, a neighbor saw Johnson's truck backed into the garage. That's the last confirmed sighting anyone has of him. Gledhill later told police the two of them argued that day. A neighbor says the argument carried into the early hours of the next morning, though that comes from a single uncorroborated witness account. And here is where the record itself splits on something as basic as the date. Gledhill points to September 20th. The state's charging document, backed by the informant, points to the 21st. There's no forensic timeline to settle it because there has never been a body to establish one. According to the informant, this is what Jennifer told him, that on the night of the 21st, she shot Matthew in the head with his own 9mm Glock. The same Glock 19X he says she'd shown him 2 nights before, as they slept, moved his body in a rooftop cargo container down the stairs and into her minivan, and buried him in a shallow grave up north. It's his account, relayed to police, not an eyewitness record, never tested in front of a jury. It is nonetheless the foundation of the murder charge. Somewhere in that same window, according to the informant's account, communication from Matthew to his 3 children stopped. 5, 7, and 11 years old. And after that night, by his account, nothing. What can be verified independently picks up the next morning. Around 6 a.m. on September 22nd, Gledhill's phone is already moving through the area where Johnson's truck will later turn up. By early afternoon, it's heading north on I-215 and then Legacy Parkway towards Davis County, with a 4-minute call to her father along the way. At 2:37, it goes dark. For roughly 2 hours, nothing. When it resurfaces just after 5, a camera at a Maverick gas station in Centerville catches her Chrysler Pacifica in frame. Later that night, between 10:37 and 11:07, a second camera at a Holiday Oil car wash on Highland Drive records her scrubbing the vehicle down, every door open. By midnight, her phone is back at the informant's house. He says she arrived visibly distraught and confessed. Now, none of that, the drive, the 2 hours of silence, the car wash, proves on its own what happened during that window. What it does is lock her phone and her vehicle into a corroborated timeline the state says lines up almost to the hour with when Johnson's body was allegedly being moved. A drive north, 2 hours of silence, a car wash before midnight, then his house. The next day, September 23rd, Johnson didn't show up to work. On September 24th, two things happened. Gledhill contacted Cotton Heights police to report an incident. The charging documents don't say what that meant, and a neighbor, along with the neighbor's mother, later told police they saw Gledhill's parents at the house that evening, roughly from 5 to 11 p.m., every light on, cleaning. Gledhill also ordered a replacement mattress that day. On September 25th, a fellow National Guard member, identified in court records only by the initials AC, asked Cottonwood Heights police for a welfare check. Johnson hadn't returned to duty. The mattress arrived on September 26th. Thomas Gledhill texted his daughter to confirm delivery. Then, on September 28th, Jennifer Gledhill called the police herself. She spoke with Officer G. Comager and formally reported Matthew Johnson missing, saying she hadn't seen or heard from him since their argument on 20th, and that he'd told her he'd been gone for a week. Comager would later describe her in his notes as sounding distracted and nervous on the call. Around this same time, the confidential informant contacted police on his own and relayed what he says Gledhill had told him 6 days earlier, bringing screenshots of deleted text and WhatsApp messages and a recorded phone call. And that's the turn. Up to this point, it's a missing person inquiry, a guardsman who didn't show up for duty, a wife's report, a friend's welfare check. From here forward, it's a homicide investigation. 2 days after the missing person report, on September 30th, detectives found Johnson's truck parked about 0.3 miles from the family home. Doorbell footage from a nearby house showed it had already been sitting there since 6:15 that morning, September 21st. Johnson's phone was still inside. The master bedroom told its own story. According to the charging document, investigators found a mattress that looked recently bought, resting on a bare wooden frame with no box spring. Fresh wipe marks on the wall behind the bed described as covered in bleach. Reddish-brown spotting on the walls, the frame, the blinds, and on the carpet, in the one spot where a sleeping person's head would rest, a circular stain that field tested positive for human blood. The Utah State Crime Lab later confirmed it came from a single male source. Comparison to Johnson's own DNA was still pending when the charges were filed in October. By the following March, prosecutors would tell a courtroom the comparison had come back and the blood was his. The cleaning evidence wasn't confined to the bedroom. The basement smelled strongly of chlorine. Black carpet on the stairs showed bleach discoloration on several steps. A carpet cleaner sat nearby, later collected as evidence. That basement connects to September 24th, the same day neighbors watched Gledhill's parents spend roughly 6 hours at the house, every light on, and the same day Rosalie Gledhill admits she ordered her daughter's replacement mattress. The search didn't stop at the house either. In Gledhill's Chrysler Pacifica, rear seats folded down for extra cargo room. Investigators found a box of powdered plant substance, a fanny pack holding 6 bags of what looked like psilocybin mushrooms, and $206 in cash. That find became the basis for the drug charge against her. At her parents' home, in a tote near the bed she used when she stayed there, a green and tan Glock 19X gun box, one handle broken, wrapped inside a child's onesie. Consistent, the informant says, with the gun he claims she showed him. That gun has never turned up. And one gap stood out by its absence. No computers, no laptops, nothing but a modem and a router in the living room. What investigators did find was an account tied to a UEFI home security system Johnson had reportedly installed himself. Reportedly, the very system that led him to discover his wife's affair. Whether any footage from it survived isn't something the record answers. Not all of the state's evidence turned up inside a house. Some of it came back on its own. The informant had told police about a rooftop cargo container, the kind you'd strap to a car roof for extra storage, that he says Gledhill used to move Johnson's body down the stairs. Detectives noted the container had been found at the home before on prior occasions and that it had since disappeared. Months later, it turned up again, recovered from a wetland in Davis County, where investigators believe it had floated to the surface after a storm. According to statements prosecutors made in court in March of 2025, testing found traces of Johnson's blood inside it. Prosecutors also pointed at that same hearing to a photograph from 2023, recovered from Gledhill's phone, showing Johnson next to a rug. They allege that same rug is one of several items, along with a mattress topper and pillows, that Gledhill later discarded. And that phone location data placed her at the site where they were found. The defense noted at the time that no DNA or blood evidence had yet tied those specific items directly to the killing. The digital record added its own layer. The informant told police he'd taken screenshots of Gledhill's messages even as she was actively deleting them. Among them, one in which she allegedly wrote, in response to a hypothetical scenario, "Let me get my shovel." And another one afterward, "I washed everything and vacuumed and it's not an issue anymore." The deletion of those messages became the basis for one of the obstruction charges. He also recorded at least one phone call with her that she then turned over to the police. Prosecutors quoted portions of it in court, including a moment where Gledhill allegedly asked him not to think of her as a monster and referred to Johnson in the past tense. One thread here, though, never got pulled all the way through. After police seized Rosalie Gledhill's phone, it was reportedly reset remotely, its location and data history wiped for the exact period investigators needed the most. No source reviewed for this case explains who did that or why. On October 2nd, 2024, Jennifer Gledhill was arrested, initially on suspicion of murder and obstruction of justice. Some early reporting at the time said she'd already been formally charged. That wasn't accurate. The charges themselves wouldn't come for another 2 weeks. On October 15th, Salt Lake County District Attorney Sim Gill announced 9 felony charges. The information was filed by Deputy District Attorney Joshua Graves. It was sworn by Braden Phelps, the Cottonwood Heights detective who served as lead affiant on the probable cause statement, with detectives Alcivar and S. Winters also named as witnesses. The case was assigned then to Judge Adam Moe of Utah's 3rd District Court. The charges: first-degree murder, classified as domestic violence, 5 counts of second-degree felony obstruction of justice, 1 each for the deleted messages, the disposed mattress, the cleaned house, the disposed gun, and the moved truck. Second-degree felony possession of a controlled substance with intent to distribute. Third-degree felony abuse of desecration of a human body. And third-degree felony witness tampering, tied to the informant's accounts that Gledhill told him it was not a crime to not say anything. She was held on a no-bail warrant. On October 21st, she appeared in court by video from jail. a commissioner, Todd Olson, signed a temporary protective order barring her from any contact with her 3 children, 5, 7, and 11 at the time. Their father's contact with them, according to the informant's account, had ended on one specific night in September and never resumed. A month later, this order cut off their mothers too. Within about a month, 3 children had effectively lost contact with both parents. One of them through what prosecutors allege was murder, the other through a court order tied to the case that followed. 3 days later, her parents were arrested. Thomas Ray Gledhill, 71, and Rosalie Christensen Gledhill, 67, on suspicion of obstruction of justice. Early headlines described Thomas as facing 3 counts, Rosalie 4. One legal analyst suggested on the record that the arrest might function as a leverage, a way to encourage Jennifer's cooperation. But here's where the record gets murky, and it's worth being precise. Those were not arrests, not formal charges. Reporting from April of 2025 through as recently as January of 2026 states explicitly that no information was ever filed against either parent. What the district attorney's office ultimately decided about Thomas and Rosalie Gledhill isn't established in the sources available for this case. On February 6, 2025, Jennifer Gledhill pleaded not guilty to all 9 counts. About 3 weeks later, at a pretrial conference, her defense signaled it would seek a reconsideration of her no-bail detention. That effort, though, came to a head at a detention hearing on March 1st. Prosecutor Emily Paulos laid out the state's evidence in open court. The blood-stained carpet, the bed slats, the DNA findings she said confirmed the blood was Johnson's, the rooftop container recovered from the wetland with traces of his blood inside, the 2023 photograph of Johnson beside the rug, the recorded call, Johnson in the past tense, the request not to be seen as a monster. Defense attorney Jeremy Diaz pushed back. Could an adult body even fit inside the container the state described? No murder weapon has ever been found. Neither has Johnson's body. And Diaz raised something specific to who Matthew Johnson was, a member of a special forces unit with the training that comes with it, as a possible alternative explanation for a prolonged, unexplained absence. It's an argument, not an established fact, but it's the core of the defense's position. The state's account isn't fully corroborated by physical evidence. The judge, however, denied bail, finding Gledhill posed what the ruling called a substantial danger to the community. That decision has held through every delay since. The following month, previously sealed search warrant affidavits were unsealed, kept sealed in total for roughly 6 months. They'd authorized searches of the marital home, Gledhill's vehicle, her cell phone, her parents' residence, and eventually, Thomas Gledhill's financial and phone records. That last category is where the 13K by Friday text first became public. It's also where reporting confirmed again that Jennifer's parents, despite their arrests 6 months earlier, had not been formally charged. Later that month, it surfaced that Prudential Insurance was withholding a $500,000 life insurance payout on Johnson's policy. Gledhill is the sole named beneficiary. The same 3 kids just barred from seeing her are not. The insurer asked the court to hold the funds until the criminal case is resolved, worried, according to the filing, about paying the money to the wrong person. The trial itself has been a moving target. Originally set for December of 2025, it moved to June of 2026 after attorneys told the court at a November hearing that they weren't ready. A separate evidentiary hearing was on the calendar for that same window, centered on a defense motion to limit the use of the informant's audio recordings at trial. It, too, slipped to March of 2026, when the defense withdrew the motion after the judge confirmed on the record that Gledhill understood the recordings could be used against her. A pre-trial conference followed on April 10th. Then, on May 7th, 2026, the trial was delayed a third time. Not for lack of readiness, but because a different prosecutor now on the case, Jamie Wideaway, was also assigned to an unrelated murder trial ahead of Gledhill's on the same judge's calendar, and couldn't prepare for two at once. The 7-day trial is now set to open with jury selection on December 7th, 2026, running through December 11th, and again from December 14th through the 16th. That's 3 trial dates set for this case since the charges were filed. December 2025, then June 2026, and now December 2027. And so far, none of them has actually happened. And as of the most recent reporting available, May of 2026, Matthew Johnson's remains have still not been found. The search has been extensive. Cottonwoods Heights Police, supplemented by U.S. Army Reserve personnel, have used foot teams and drones to comb the Farmington Bay wetlands of the Great Salt Lake, territory tied to Gledhill's GPS data from that September afternoon. It's difficult terrain. At least one news outlet consulted a former FBI agent about just how hard body recovery can be in ground like that. For over a year, the searches have continued, intermittently, without results. That fellow guardsman from earlier has a name, John Hash, a Green Beret who spent 12 years in the same unit as Matthew Johnson. 12 years is a long time to serve beside someone. When the searches went quiet, Hash didn't. His message stated publicly and simply, you don't give up. You leave no one behind. You bring him home. It's also worth noting what the record does not contain. No source reviewed for this case documents any confirmed investigative error, evidence suppression, or any kind of procedural misconduct by Cottonwood Heights Police or the District Attorney's Office. The reset phone is still the one thread nobody has explained. A case like this is defined by as much what hasn't been settled as by what has, and several of the questions raised along the way never got answered. So let's start with what still doesn't add up. The reset phone. No source has ever explained who did it or why. The $13,000 text, sent 3 days before the night prosecutors alleged Johnson was killed, never explained on the record. Whether Thomas or Rosalie Gledhill will ever face formal charges, still, as of the most recent reporting, an open question. An arrest from October of 2024 that has never resolved into anything more or less. And the DNA match itself, the blood investigators say is Johnson's, rests on what prosecutors told the judge in open court. The underlying lab report has not been independently reviewed in the reporting of this case. Then there's what nobody has been able to find at all. The exact night of the killing. The 20th or the 21st. Depends on whose account you believe. And there's no forensic timeline to settle it, because there's no body. The precise location where investigators think Johnson is buried is still unknown. GPS data points towards the wetlands of Davis County in general, not a spot on the map. And the identity of the informant himself, the one source from the very start of this story, the one whose account built almost all of it, has never been made public. Even the people at the center of it remain, in some ways, undefined by the public record. Beyond his National Guard service, Matthew Johnson's civilian life was not established in the sources reviewed for this case. Neither was Jennifer Gledhill's occupation or background before her arrest. Here is where this case actually stands, as of the most recent information available. Jennifer Gledhill has pleaded not guilty to all 9 counts. She's waived her right to a preliminary hearing and has been ordered to stand trial. She remains in custody, held without bail. No jury has heard this case. No jury has reached a verdict. Under the law, she is presumed innocent unless and until that changes. Her parents were arrested in October of 2024. No formal charges had been confirmed against either of them. 3 children, 5, 7, and 11, when their father disappeared, still haven't been allowed contact with their mother. A $5,000 life insurance policy sits frozen in legal limbo. And Matthew Johnson, a soldier, a father of 3, a guardsman who served for years beside people like John Hash, has not been found. Not in the wetlands outside Salt Lake City. Not anywhere else investigators have searched. Whatever a jury decides this December, it will decide it without him. That trial is scheduled to begin with jury selection on December 7th, 2026. Until then, this is a story without an ending. 3 kids who still haven't been allowed contact with their mother. A $13,000 question nobody has answered. A body nobody has found. Just a date on a calendar. And a family still waiting to find out what a jury believes happened to Matthew Johnson. On a June afternoon in rural Wisconsin, a highway worker was cutting grass along the shoulder of a quiet country road when he found 2 suitcases lying in the tall grass. He moved them out of the path of his mower and kept working. He had no idea of knowing yet that each suitcase contained a woman's body. One victim would be identified within days. The other would remain a Jane Doe for weeks, known only by a facial reconstruction sketch that the public mocked online. Until it worked. Today, we're diving into the case of Steven Selig, a former Wisconsin police officer known online as Mr. Handcuffs, and the 2 women he admitted to killing during what he described as consensual breath play. This case involves detailed descriptions of violence and the concealment of human remains. We'll walk through it carefully, sticking to what the record actually shows, including the parts of this case that even now remain unsolved. So let's start with who Steven Selig was, before any of this became public. Steven Mark Selig was born on October 29, 1961. According to background reporting on his career, reporting we should flag as not independently verified through personnel records. He began working in law enforcement in 1984 as a patrol officer with the Mequon Police Department in Wisconsin. In 1989, he moved to the West Allis Police Department, also as a patrol officer. He would spend more than a decade there. In 2001, that career ended. Selig resigned from the West Allis Police Department following an off-duty incident involving a handcuffed woman near his apartment. According to the same background reporting, an internal investigation found that he'd been stalking women while on duty and running an unauthorized side business selling phone service to women he'd contacted. No criminal charges were filed at the time. And so we want to be precise about what this is and isn't. This is a reported background, not a fact drawn from a personnel file or court record we've reviewed directly. The underlying internal affairs documents themselves weren't located for this account. So we can't tell you more about what the investigation found beyond those 2 allegations, the stalking and the side business. But if it's accurate, it describes conduct involving women, restraint, and boundary-crossing behavior more than a decade before the deaths at the center of this story. Whatever it meant, it didn't end his career through a criminal charge. It ended quietly, through a resignation. Let's move forward to 2012. Selig meets a woman named Jenny Gamis through an online contact. According to the criminal complaint against him, as quoted in a later Wisconsin Court of Appeals opinion, Selig and Gamis had connected online and then met in person. The complaint describes both of them using online S&M and bondage websites. Selig used the alias Mr. Handcuffs. Now, this detail matters because it's the same avenue through which Selig would later meet his second victim, Laura Simonson, the following year. Now, the timing of what happened to Jenny Gamez is genuinely contested in the record, and we're not going to smooth that over. Some reporting places her death in August 2012, but the criminal complaint itself, the primary legal document in this case, is a little bit more vague. It describes Selig meeting Gamez in person and her death occurring in late 2012 or early 2013. Where a court document and secondary reporting disagree like this, we're going to treat the complaint's own language as the more authoritative account, while telling you plainly what the other outlets have reported with a more specific date. But the bottom line, confirmed either way, sometime in the late 2012 to early 2013 window, Jenny Gamez died during what Selig would later describe to investigators as a breath play encounter at a hotel in Kenosha County, Wisconsin. The specific hotel has never been identified in the sources reviewed for this story. What happened next is where this case starts to become almost impossible to comprehend. According to the criminal complaint, Selig placed Gamez's body in a suitcase and transported it to his apartment in West Allis, Wisconsin. He kept it there. One account states that at one point, he stored her body in his refrigerator. He did not go to the police. He did not report a death. He kept her. The Wisconsin Court of Appeals opinion itself separately states that the second death occurred 14 months after the first. That figure doesn't resolve the disputed date we just laid out. It's simply the gap of the court's own opinion describes between the two deaths, and it's consistent with either version of Gamez's death window. 14 months later, it happened again. On November 2nd, 2013, Selig and a woman named Laura Simonson checked into the Microtel Inn in Rochester, Minnesota. Hotel confirmation records confirmed this. Simonson was 37 from Farmington, Minnesota. Like Gamez, she had met Selig through an online bondage and S&M website. Sometime on November 2nd or 3rd, Laura Simonson died. The circumstances, again per the criminal complaint and the resulting investigation, were the same. A breath play encounter, choking, at the hotel. Selig checked out on the Microtel alone on November 3rd. 20 days later, on November 22nd, 2013, Laura Simonson's mother reported her missing to the Farmington Police Department. That report opened a formal missing person investigation, one that, at the time, had no known connection to a death that had already happened, unreported, a year earlier in Kenosha County. And here's the detail from that criminal complaint that turns this from a story about one bad night into something else entirely. At some point during 2013 and 2014, Selig moved Simonson's body in a suitcase and kept it in the trunk of his vehicle. He also moved Gamez's body back into a suitcase. For a period of time, both women's bodies were in the vehicle of his trunk, together. We're not going to speculate about what that meant to him. We don't have the evidence of his state of mind at that point, and we're not going to make it up. But hold on to that image, because prosecutors would later point to it directly in court as evidence of something particular about how Selig regarded what he had done. For roughly 7 months, that's where things stood. 2 women dead, 2 families. One of them actively searching, one of them not yet aware anything was wrong, because Gamez had reportedly told people she was relocating and had not been reported missing at all. Then on June 5th, 2014, a Town of Geneva Highway Department employee was mowing the grass along North Como Road. This is in Walworth County, Wisconsin. He came across 2 suitcases in the tall grass along the shoulder. He moved them out of the way so that he could keep working. They were soon found after by a passerby, drawn, according to the record, by swarms of flies. Inside were 2 bodies. According to the criminal complaint, one, the more decomposed of the 2, was partly wrapped in a plastic garbage bags with the hands bound behind the backwoods rope. The other was unclothed, with a rope wrapped around the neck and a sexual ball gag strapped to the mouth with a collar. 2 women, 2 suitcases, no identification on either. The town of Geneva police opened an investigation into the discovery, and 5 days later, on June 10, 2014, Wisconsin authorities made contact with Rochester, Minnesota Police Department, connecting this rural Wisconsin roadside discovery to an open missing persons case nearly 100 miles away. The pieces started coming together very quickly after that. On June 12th, the Rochester Crime Scene Unit and the Minnesota Bureau of Criminal Apprehension processed the room at the Microtel Inn where Zelig and Simonson had stayed the previous November. Staff at the hotel had recognized Simonson from a missing persons flyer and contacted police. Investigators now had documentary evidence, the hotel's own registration records, placing Zelig and Simonson there together on November 2nd, 2013, and showing Zelig checking out alone the next day. On June 24, 2014, authorities announced they had developed physical evidence connecting Zelig to both bodies found in the suitcases, Simonson's and the second victim's, who at that point was still unidentified. Zelig was taken into custody. The exact date is one of several small details this case on record can't fully pin down. Different outlets report June 25th, 26th, or 27th. And it's possible those dates simply reflect the difference between initial detention, formal booking, and his first court appearance, rather than a real contradiction. What's confirmed is this: he was booked into Walworth County Jail on 2 counts of hiding a corpse and held on $1 million bond. The second victim was still unidentified because Jenny Gamis has never been reported missing to this point. Her family reportedly believed she had simply relocated. There was no missing person file to check against. So Walworth County released a composite, a facial reconstruction sketch to the public. According to secondary reporting, that sketch drew criticism, even ridicule online, for its perceived quality. We can't independently verify how accurate that characterization is, but what we can tell you is what happened next. Family members recognized similar features in it. That recognition led investigators to Jenny Gamis, and her identification was confirmed through dental records by June 28th to 30th, 2014. She was reported at that press conference as 21 years old from Cottage Grove, Oregon. Now we need to flag something here because it matters for accuracy. Gamis' age is one of the most inconsistently reported details in this entire case. 18, 19, 21, 29, all 4 numbers appear across different outlets and different years. The 21-year-old figure is the one tied most directly to the original identification announcement in June 2014. The 19-year-old figure shows up most often in later reporting, around the time of sentencing. No birth record or official document was located to settle it, so we're not even going to pretend this is resolved, because it isn't. Let's pause on what investigators actually had to work with by this point, because it's worth being clear about the difference between what different pieces of evidence could and couldn't prove. The suitcases, the rope, the garbage bags, the ball gag, and the collar. All of that was physical evidence establishing how the bodies had been transported and concealed. None of it, on its own, established how either woman died. That came only from 2 other places: what Zelig told the investigators directly, and a forensic examination. The hotel registration records out of Rochester were documentary evidence, placing Zelig and Simonson together at a specific place and time, and showing he left alone. Officials also said they were developing similar hotel records tied to Kenosha County and Gamis, though the specific hotel and the contents of those records were never made public in the sources reviewed for this story. And the online bondage and S&M websites, the digital thread running through both cases, established the method Zelig used to find and contact both women, though the full extent of his activity on those sites, and whether he contacted others the same way, was never confirmed one way or the other. What investigators didn't have is worth noting too. No surveillance footage, no cell site data, no GPS tracking shows up anywhere on the record of this case. No financial or transactional evidence ties directly to either death. Based on the sources reviewed for this account, the case against Zelig rested primarily on physical objects, documentary records, forensic identification, and ultimately, his own words to investigators. During questioning, Zelig admitted to causing both women's deaths. He described the encounters as consensual breath play and characterized both deaths as accidental. That's Zelig's own account, given to investigators, an allegation from the person facing prosecution, not an independently established fact. Captain John Sherwin of the Rochester Police Department's Investigation Division, the public spokesperson on the Minnesota side of this case, confirmed publicly that his department was investigating Zelig's activity on bondage and S&M websites. Investigators also obtained a DNA sample from him. According to the report on the case, reporting, we should note, is secondary, without a primary lab report reviewed for this story. That DNA was later matched to genetic material recovered from the ropes used to bind the victims. It's worth noting, no investigative error or misstep is identified anywhere in the sources reviewed for this account. No mistip, no mishandled evidence, nothing of that kind. What the record does show is this: for as long as this case remained open, nobody told Jenny Gamez was missing at all. Asked directly about the possibility of additional victims, the town of Geneva Police Chief Steve Hurley didn't rule it out. His answer on the record: "I think we leave that question wide open for now. No source reviewed for this story confirms that any additional victims were ever found." But no source closes that question either. It was left open in 2014, and as far as the public record shows, it has stayed open. Now let's walk through how the legal case actually unfolded, because Zelig wasn't prosecuted once. He was prosecuted 3 separate times, in 3 separate courts, for 3 separate sets of charges. First, we have Walworth County, where the suitcases were found. He was charged there with 2 counts of hiding a corpse, 1 for each victim. Second, Kenosha County, where Jenny Gamez died. In August 2014, Zelig appeared in Kenosha County Court on new charges, an escalation from the corpse hiding counts he'd already been booked on in Walworth County to a homicide prosecution built specifically around Gamez's death. He was ultimately charged with first-degree intentional homicide, using a dangerous weapon, and hiding a corpse, specific to Gamez. Then third, Olmsted County, Minnesota, where Laura Simonson died. He was charged there with first-degree premeditated murder, second-degree intentional murder, and second-degree unintentional murder. The exact date of those charges were filed isn't really confirmed in the sources reviewed for this story. What is confirmed is the outcome, which we'll get to. 3 counties, 3 sets of charges, 2 states, all of it stemming from the same 2 deaths and the same pattern each time: the body kept, not reported. Let's begin with the Kenosha County case, the Gamez homicide prosecution, because this is where the most significant pre-trial legal battle in this story played out. Prosecutors wanted to introduce what's called other acts evidence. That's details of Laura Simonson's death, used as evidence in the separate case about Jenny Gamez's death. Their argument was that the 2 cases were, in their words, inextricably intertwined, that the pattern between them showed a plan, a modus operandi, an identity, a motive, in an absence of accident. The judge in that case, Bruce Schroeder, wasn't quick to agree. He denied the motion twice. His reasoning, at least initially, was straightforward. Simonson's death happened after Gamez's, so on its face, it couldn't logically prove what Zelig intended when Gamez died. And beyond that, the judge found the evidence more prejudicial than it was worth. So twice, prosecutors went back and tried again. On a third attempt, the state succeeded. Judge Schroeder ruled the evidence admissible to show what the court described as purpose, plan, and modus operandi. And it's here that prosecutors return to that image we asked you to hold on to earlier. Both bodies kept together in the trunk of Zelig's cars for a period of months. The state pointed to that fact directly, arguing it showed Zelig regarded the bodies as what prosecutors characterized as prized possessions. And we want to be exact about what that is. It's an argument made by the prosecution in support of its position of intent and pattern, not a psychological fact established independently on that argument, and not something Zelig himself confirmed. The court didn't rule on whether that characterization was true. It ruled only that the underlying evidence, the Simonson case details, was admissible in the Gamez prosecution. Now, one note we must add here for the sourcing, because it matters for how confident we can be in everything you're hearing about this legal fight. The Wisconsin Court of Appeals opinion that documents all of this doesn't actually use the names Jenny Gamez and Laura Simonson. It refers to the victims by fictitious names, Julie Gerhard and Lisa Shepard, stated explicitly in the opinion as a way of protecting the victims' identities. The opinion itself never says which fictitious name maps to which real victim. The connection this account draws, Gerhard to Gamez and Shepard to Simonson, is based on matching circumstantial detail. The same Kenosha County case number, the same suitcase discovery in the town of Geneva, the same physical descriptions of how each body was found. This is a reasonable inference, not something the court states outright. And so we're just telling you that because it's that kind of gap that's easy to paper over, and we'd rather you know it's there. Now, that ruling, not a verdict, not a confession, just a pre-trial evidentiary decision, is what appears to have changed the direction of the case. About 3 weeks after that final ruling, Zelig pleaded guilty in Kenosha County to an amended charge: first-degree reckless homicide, using a dangerous weapon and hiding a corpse. That plea was entered around January 2016. In March 2016, Judge Schroeder sentenced him to 35 years in prison for Jenny Gamez's death. Nearly a year later, on February 3rd, 2017, Zelig pleaded guilty in Olmsted County, Minnesota, to 1 count of second-degree murder, intentional but not premeditated, for the death of Laura Simonson. Judge Pamela King sentenced him the same month to 25 years, ordered to run consecutively after his Wisconsin sentence. Then, in August 2017, the third prosecution concluded. Zelig pleaded guilty in Walworth County to both counts of hiding a corpse. On October 13th, 2017, he was sentenced to an additional 10 years. When we add it all up, the total is 70 years. 35 and 10 in Wisconsin plus 25 in Minnesota, with the Minnesota sentence specifically ordered to run consecutively, meaning it only begins after the Wisconsin time is served, not alongside it. One source additionally cites a minimum period before parole eligibility of 58 years, described in that source as a de facto life sentence given his age. That specific de facto life sentence framing is a characterization from secondary reporting, not a formal legal designation. But the arithmetic behind the 70-year total is confirmed across multiple independent outlets. Steven Zellick was in his mid-50s at the time of that final 2017 sentencing. You might expect that this is the end of the story, end of the video. However, it wasn't. In 2019 and 2020, Zellick went back into court, seeking to withdraw his guilty plea in the Kenosha County case. His claim is known as ineffective assistance of counsel. In plain terms, he argued that his own trial lawyers gave him advice that fell short of what the law requires. Advice bad enough, he said, to have changed how this case turned out. So here's what he actually alleged, according to his own post-conviction filing. He said his attorneys told him he could still appeal Judge Schroeder's other acts ruling, even after he pleaded guilty. He said that advice was wrong, and that if he'd known better, he wouldn't have pleaded guilty at all. He claimed he'd wanted to go to trial from the beginning, had rejected an earlier plea offer, and had only started seriously considering a plea after that third successful other acts motion. Now, we want to be very clear about this. Every part of that is Zellick's own account, laid out in his own filing. It's an allegation, not an established fact. To test a claim like this, Wisconsin courts hold what's called a Machner hearing. It's a hearing where the defendant's trial lawyer explains under oath what advice he actually gave and why. So a judge can weigh that whether that advice fell short of the legal standard. Zellick got only part of that hearing though. His trial counsel testified that he hadn't directly told Zellick he could appeal the ruling after pleading guilty, but that he had told him he needed to assume he could not. Before the hearing could finish, before Zellick's post-conviction lawyer could finish questioning trial counsel, and before Zellick himself could testify, Judge Schroeder cut it off. He denied the motion right there, reasoning that his own earlier other acts ruling had been correct. So even bad advice about appealing it wouldn't have changed anything. In his own words, no harm, no foul. Zellick appealed that denial. On November 25th, 2020, the Wisconsin Court of Appeals District 2 ruled, and the decision split into two separate findings. It's worth taking them one at a time. The first finding was about fairness of process. The Court of Appeals said Judge Schroeder was wrong to cut the hearing short, that Zellick should have been allowed to finish presenting evidence and testimony relevant to his claim. So, the appeals court reversed the denial of his motion and sent the case back down for that hearing to be completed. The second finding was about the evidence itself. The same appeals court separately upheld Judge Schroeder's original other acts ruling, the decision to let Simonson inform the Gammis prosecution case, as a proper exercise of discretion. In other words, even if Zellick eventually wins the right to withdraw his plea, the evidentiary decision that reportedly pushed him towards that plea in the first place was found not to be wrong. So two different questions, two different answers. Whether the hearing was fair to him, sent back, unresolved. Whether the evidence was properly allowed, settled, upheld. And that's where the public record, as far as this research was able to establish, runs out. No source reviewed for this story confirms what happened at the remanded hearing. No source confirms whether Zellick's Kenosha County plea was ultimately upheld, formally withdrawn, or resolved some other way. His current custody status, where he's being held, within which state's correctional system, was not independently confirmed through a direct records lookup for this story either. As far as the public reporting we could locate is concerned, this case's final chapter, in the Gammis prosecution specifically, remains open. However, that's not the only loose thread left here. There's the question Chief Hurley raised and never got an answer to, whether there were any other victims beyond Gamez and Simonson, found through the same online alias, the same pattern of contact. It was left wide open in 2014, and it's still open now. There's also Jenny Gamez's age, reported as 4 different numbers across nearly a decade of coverage, with no single document available to settle it. There's the precise date of her death, a detail the criminal complaint itself only pins down to a several-month window. And there's the DNA evidence tying Zelik to the ropes found on both victims. Reported, but never confirmed through a primary forensic document in the sources available for this story. Think too about how differently these 2 women's disappearances were treated, simply because of what the people around them knew. Laura Simonson had a mother who noticed she was gone and called the police within 3 weeks. That report, filed in Farmington, Minnesota on November 22, 2013, is the reason there was any missing persons file at all, for investigators to eventually connect to a rural Wisconsin roadside a year later. Jenny Gamez had no equivalent starting point. She had reportedly told people she was relocating, so nobody filed a report. There was no search underway for her at all. Only eventually, a police sketch that the public reportedly mocked online, until someone who knew her looked at it and recognized her anyway. What we do know, without any hedging, is this. Steven Selig was a police officer for roughly 17 years, before resigning under circumstances involving a handcuffed woman and an internal investigation into stalking. He met 2 women, Jenny Gamez and Laura Simonson, through the same kind of online contact, using the same alias. Both died during encounters he described, in his own words, to investigators, as consensual. He did not report either death. He kept both bodies, one in a suitcase in his apartment, and at one point, reportedly in his refrigerator. Both eventually together in the trunk of his car for months. In Gamez's case, for well over a year. He left them on a rural roadside where a highway worker found them while cutting grass. He was prosecuted 3 times, in 3 courts, in 2 states. He pleaded guilty each time, and then in 2020, 4 years after his first sentencing, an appeals court found that he had been denied the full evidentiary hearing required to test his claim that his Kenosha County plea should be withdrawn, while in that same ruling, upholding as proper the underlying evidentiary decision that, by his own later account, had made this position feel impossible to fight. 2 women went missing from their own lives. One reported, one not. Both were found, eventually, in the same stretch of grass, both suitcases left there by Zelik's own admission, by the same man. What happens next in the courtroom that started this, whether that plea falls or stands, or it gets resolved some other way entirely, is, as far as the public record shows, still an open question. If this case stuck with you, let us know in the comments. And if you want to see more cases like this one, consider subscribing so you don't miss the next one.